Anna, can you please state your name for the court?
Yes, my name is Nana Leslie.
This case opens in a place that feels familiar in American courtrooms, the fragile line between accountability and mercy. We're introduced to a defendant who isn't denying what happened. She's admitting a bond violation, but asking the court to see the work she claims she's been doing behind the scenes. Treatment, AA meetings, sponsors, recovery coaches. On paper, it sounds like a comeback story in progress. But here's the tension. Courts don't operate on intention. They operate on patterns. Judges aren't tasked with believing in someone's future. They're tasked with protecting the public in the present. Every word you're about to hear from defense counsel is carefully framed to answer one question. Is this relapse a stumble or proof that the system isn't working? This isn't just about one drink. It's about trust. Bond is a privilege. It's the court saying, we believe you can follow rules without being locked up. When that trust breaks, everything changes, and that's what makes this hearing so dangerous for the defendant. The defense is trying to show effort. The court is about to weigh that against a history that keeps repeating itself. Listen closely, not just to what's said, but to what's implied. Because in this courtroom, sympathy competes with public safety, and only one of them can win.
Your Honor, we're waiving the preliminary examination. I know there's a bond violation hearing that needs to be addressed.
Yes, you need to address that now.
Your Honor, she will be acknowledging and admitting to the bond violation. And hopefully I can say a few words after that.
Go ahead.
Your Honor, I did submit some documents to the court. Hopefully Your Honor has had a chance to review those. She's been treating with the Home of New Vision since about April of this year, and she attends AA meetings pretty regularly. Nevertheless, this is...
When did you send documents to the court?
Yesterday, Your Honor.
Okay, go ahead.
That looks like one of them. She's been treating with Home of New Vision since April. She's going to AA quite a bit. It is a struggle, though, Your Honor, and she admits the struggle. She has gone back to Home of New Vision. She has spoken with them. She's told them about what's went on. They're giving her some things to do to redouble her efforts. I'll just give Your Honor a minute to read if you'd like.
Go ahead.
They've had her go out and get a sponsor. She's been working with a sponsor now. I've attached a letter from her, Your Honor. She's really been pushing Nani to get new strategies in place, new ways of dealing with things, new ways to address her thoughts and behaviors as it relates to drinking. And she appreciates that pushing from the sponsor, Your Honor, and she can tell you that as well.
Go ahead.
She has been putting in some very serious hard work, Your Honor. We're hoping that the court can take that into consideration and please give her a second chance at this, Your Honor. She went to Home of New Vision again this morning, and they hooked her up with a recovery coach. She gave me her card from her, and she says that they've been also giving her new strategies as well in dealing with this. So she does admit the violation, Your Honor. She is a bit ashamed of herself, given that she's trying to put in a serious track record to get to this point. But she's dealing with it as proactively as she possibly can.
Well, then when it was asked about, why didn't she just say what happened?
Freaked out, got nervous. There's no good excuses for it, Your Honor.
Well, but there were numerous times she could have, like a better term, just come clean on it. She didn't do it.
This is the moment where the narrative cracks. It's no longer just about drinking. It's about honesty. The defense concedes what the court already suspects. She had chances to tell the truth, and she didn't. That matters more than people realize. Judges expect mistakes. What they don't tolerate is evasion. In legal terms, this shifts the issue from relapse to reliability. If someone can't be trusted to report a violation, how can the court trust them to self-regulate on bond? The system depends on transparency. Without it, every safeguard becomes meaningless. Think about the psychology here. Addiction already erodes judgment. Add fear of consequences, and suddenly every interaction becomes strategic. Do I tell the truth and risk jail, or do I stall and hope it passes? That's the internal battle playing out in real time.
It's hard.
It's not like they just asked her once. Then they wanted her to take an ETG. And she sat there and skirted around all of that.
She got scared, Your Honor.
This wouldn't be anything.
Your Honor, the concern of the people here is that this is a true fourth OWI. Priors in 2005, 2015, and 2018. The alleged BAC at the time of the stop for this case was a .214, and we have a confirmed drinking event while she's on. The public safety risk defendant poses is extremely high.
This is where the emotional tone of the courtroom hardens. The prosecution reframes everything we've heard. Treatment doesn't erase history. Effort doesn't erase outcomes. A fourth OWI isn't a lapse, it's a pattern. A 214 BAC is nearly 3 times the legal limit. That's not casual drinking. That's impairment at a level that kills people. And now add the most damning detail. This happened while under court supervision. That's not defiance. It's proof that the existing structure failed. The prosecutor isn't just arguing law, they're invoking consequence. Every judge carries the invisible weight of past tragedies, cases where leniency became regret. When a court releases someone who later harms someone, that decision echoes forever. This is why scram or remand isn't procedural, it's existential. The court isn't choosing between punishment and mercy, it's choosing between risk and control. And that raises a brutal question. At what point does compassion become negligence?
People are concerned that if she's not put on a scram, or if there are not other steps taken to make the public safe about what might happen. This event, fortunately, it seems like it is being taken seriously. The history of the defendant with alcohol cannot be ignored by the people. We are requesting either a remand or a scram tether installation before she leaves this immediate vicinity.
How come she didn't take the ETG?
Right then and there, Your Honor.
Hmm?
Right then and there, Your Honor. She did take the ETG. It came back to
At
on-site.
what point?
I don't know that, Your Honor. Yeah, you of course can talk when the court's ready for you. Yeah. Are you asking Ms. Wesley?
I'll
Your Honor?
hear from her.
Okay.
Your Honor, I did take it the same day that I was asked to take it. I wasn't in town. I told her I wasn't in town, and she said that I needed to take it, which I did do. I came back to Ypsilanti to take it. I was not in the area.
I guess my question, you took it on what day?
The same day that she requested the 3rd.
Why didn't you tell her you did?
I did tell her, Your Honor.
When?
I told her,
What? Okay, let me ask this. Why was your story changing?
I was nervous when she called me, and I told her that I wasn't in the area right away. And she said, well, where are you? And I said, I'm out of the area. I'm up north. And she said, well, your device isn't up north. It's in Detroit. And I told her that I would come back if she needed me to. And she said, well, I can give you some places where you were at to test. And I said, I will try to make it back so I can do so. And I did do that. I did it the same day she asked me to.
Your Honor, if I may, the report that I received does indicate the testing was done on-site, not community corrections. And I also have that same information, I think the court has as well, where the initial information that's provided by the defendant to community corrections is that she was up north and unable to do that. But that 20 minutes before this contact, GPS and SoberLink said she was in Detroit. And then the defendant said she didn't have it with her, SoberLink.
Here the court sees what no apology can undo. Contradiction. Technology doesn't forget. GPS doesn't panic. Data doesn't lie to protect itself. When a defendant's story diverges from objective records, credibility collapses. This isn't about geography, it's about control. Every shifting explanation signals instability under pressure, and courts measure reliability under stress, not comfort. If the truth changes when stakes rise, the system cannot rely on self-reporting. Judge Simpson is watching something critical. Not the mistake, but the reaction to being caught. Recovery isn't just abstinence, it's accountability. The ability to say, I failed, without distortion. From a judicial standpoint, this is a warning sign. Not malicious, not evil, but unsafe. The law doesn't require bad intent, only foreseeable harm.
I didn't physically have it with me, Your Honor. I wasn't with the SoberLink. That's what she was asking me, the corrections officer. And I told her
Where up north were you?
in Dryden, Michigan.
In where?
Dryden.
So, Your Honor, I mean, bottom line, she did come back to do the ETG knowing that it would be positive and knowing that this court would take that into account. She has been scrambling this past week to try to get things into place. I think with everything she's been doing since April, with what she's doing now in combination with the scram tether would keep her on track, Your Honor.
How is that going to keep her on track?
It'll make sure that she can't drink.
No, she can still drink.
Well, tell her she does.
I promise you.
Much like this did. And then when they call her on it, she starts all kinds of excuses, Mr. Allen.
I'm begging you, Your Honor, I will not. I have, at the time, did not have a sponsor in place. I have a sponsor now. I'm working with Home of New Vision on a weekly basis. I see the treatment coordinator. She did submit a letter to say that. I told her right away.
Ma'am, this is the fourth time. Then you get caught the fourth time. You're almost 3 times the legal limit. You get a bond, you're out. We put you on a SoberLink. You drink. Then when you're called on it, you begin this whole thing of going around it and everything. And that's what gets you into treatment.
Well,
So what you want me to do is you want me to take the chance of putting you on a scram tether, allowing you to get behind the wheel of a car, maybe having drank,
Your Honor,
and hurt or kill somebody. Not going to happen.
Your Honor, I won't do that. I have.
Bond revoked. Defendant's remanded. I'll adjourn this out 1 week.
This is the line where discretion ends and responsibility begins. Judge Simpson is no longer speaking in hypotheticals. He's speaking in outcomes. Courts do not get to say, I didn't think it would happen. Every release carries risk, and here, that risk has already materialized. What's powerful about this moment is its clarity. The judge strips the argument down to its core. What happens if you're wrong? Not if she improves, not if treatment works, but if it fails. Because when it fails, the cost isn't emotional, it's physical. It's a stranger on the road. It's a family that never comes home. Bond revocation isn't a punishment for relapse, it's a boundary for danger. The court isn't saying, you're hopeless. It's saying, I cannot gamble with lives. This is the unromantic side of justice. No speeches, no dramatic pause, just consequence. And it's a reminder that in court, sympathy is not a shield. Patterns matter, risk matters. Public safety always outranks personal intention.
We are waiving the preliminary examination.
I'll
Your Honor.
adjourn it out 1 week. She can do the waiver then, but she's going to do this now. This case, People versus Ayanna Johnson.
On behalf of the people.
Hello.
Hi, how you doing?
What's your name?
Ayanna Johnson.
All right. Ma'am, you are before the court on a count complaint that alleges, I can find the paperwork here, that on or about October 16, 2023, at the location of West Michigan Avenue near Munger Road in Pittsfield Township, Washington County, State of Michigan, count 1 alleges that you did operate a motor vehicle while intoxicated. Do you understand the nature of that charge?
Yes, sir.
That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court cost. The court could order community service and any rehabilitative services the court deems necessary. Could also order your vehicle immobilized. Could order you also to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes, sir.
All right. Count 2 alleges that you were operating by a minor with any blood alcohol content. That is also a misdemeanor punishable by up to 360 hours of community service, a $250 fine plus court cost. Court could order rehabilitative services, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, man?
Yes, sir.
It looks like these are charged in the alternative potentially. All right. First question I have for you, ma'am, is do you wish to be represented by an attorney?
I don't know what that means.
You want an attorney to assist you and represent you in this case?
To be honest, I don't know what an attorney does. So
You don't know what an attorney does?
no, I don't know nothing about the court. So no,
How old are you?
19.
An attorney is somebody trained in the law that can help you understand the nature of the offenses. They would go through all what's called discovery, which would be the information that the prosecutor has regarding this case. That could be video, the police report, explain to you the ramifications of that information, as well as if there were a plea agreement, meaning that you would plead to some charge, which you were sitting in the courtroom while I was doing some of those. They would explain to you the consequences of that plea and what it could possibly mean for you. So they can assist you throughout the entire process. If you could not afford to hire an attorney, then the court you would be given an attorney to represent you. You understand that?
Yes, sir.
This is the system doing what it's supposed to do. The judge doesn't rush. He doesn't shame. He educates. The right to counsel isn't symbolic. It's structural. Without it, a defendant becomes a spectator in their own case. Charges become noise. Consequences become invisible until they arrive. Notice the tone. It's patient, clear, almost parental. Because the court recognizes vulnerability. This isn't manipulation. It's confusion. Legally, this matters. A waiver of counsel must be informed. If someone doesn't understand what an attorney does, they cannot waive that right. So the court pauses the machinery of prosecution and installs understanding. That's due process in action. It's easy to forget that justice isn't only about punishment, it's about legitimacy. And legitimacy requires that the person standing there knows what is happening to them.
All right. So now I'll go back to my question. Do you wish to be represented by an attorney?
Yes, sir.
This is a public defender case.
Good morning, this is the public defender on behalf of Ms. Johnson. We will waive any further reading and stand mute to the charges and request a new pretrial date, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to April 3rd, 2024, 9 a.m. Alleged BAC in this matter.
Your Honor, the alleged BAC is very low, it's 0.053, but there were 10 milligrams per milliliter of delta 9 THC.
THC.
Correct.
Need a
I also want to note that this was a two-car crash.
there was an accident. Anything you want to say before I set bond in this case?
Your Honor, I would, seeing as Ms. Johnson is young, she stated she doesn't have any prior records or prior convictions. I would ask for a personal bond and any testing that the court may allow.
Are you in school?
Yes, I am.
Where?
I go to Pathways to Success.
So let me just ask you, you have your high school diploma?
Not yet.
You live on your own?
I live with my mom.
Mom's here? Okay, so mom does know about this. Defendant's bond will be set in the amount of $15,000 personal or cognizance bond. Young lady, I'll order standard conditions. That includes no assaultive behavior or use or possession of any weapons or ammunition. There is to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes, sir.
I'm also going to order that she report over to the Department of Community Corrections. It's She's gonna report over for placement on a SoberLink unit, given her age and the fact that there was alcohol in her system and there was an accident in this case.
Okay.
Did you hear me?
Yes, I was just telling her SoberLink is something she's gonna blow into 3 times a day.
All right, and then I'm gonna order a urine test. All right, let me ask this. Do you have a medical marijuana card?
No.
I'm gonna order that she report to community corrections for a urine test 2 times per month. Also, so she'll have those 2 things to do twice a month. She'll have to report there for that, and she'll be on the SoberLink. See her in a month. Thank you.
Thank you.
These 2 cases reflect the full spectrum of judicial decision-making. One defendant is remanded because history and behavior prove risk. Another is given structure because inexperience and youth suggest potential. Judge Simpson's rulings are not emotional, they're calibrated. In the first case, repeated failure under supervision makes release unsafe. In the second, absence of record and age justify conditional trust. That's what court is. Risk assessment under law, not forgiveness, not vengeance, balance. Bond conditions aren't symbolic. They are behavioral contracts, SoberLink, testing, reporting. Each one is a lever, designed to detect failure before it becomes tragedy. What we witness here isn't drama for spectacle, it's consequence engineering. Every order is a prediction about human behavior. And the court is always asking the same question: who bears the cost if I'm wrong? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.